So you or a loved one have a workers' compensation claim, and you've been treating for a while, maybe you had some surgery, and now you've gotten to the place where your doctor says you've reached maximum medical improvement, and they've ordered something called a functional capacity exam. I encourage you to look on our website as to what that is. We'll talk more about that in a minute. And that functional capacity exam has given you your permanent physical restrictions that result from your work injury. And those physical restrictions say you can't go back to your old job that you were doing before the accident. Your old job won't accommodate you. And now you hear the insurance company wants a demand letter, from you or your attorney. What is that? And what does that involve? Hi, my name is Joe Miller, workers' compensation attorney in Virginia and North Carolina. And today that's exactly what we're going to talk about. We're going to give you a little bit of inside baseball, so to speak, on what a demand letter is and what goes into it. And I'm going to tell you in advance that, just as a caveat, I'm not going to give away all the things I could say. Another caveat is that this is not meant to be a do-it-yourself guide, so to speak, to demands. I strongly recommend against anyone attempting to negotiate his or her workers' compensation claim on your own, particularly if it's a claim where you have severe permanent injuries and you have a lot of future medical stuff that you're looking at. Best bet is to consult with and retain an attorney who specializes and focuses on workers' compensation in either Virginia or North Carolina, okay? The purpose, rather, of this video really is to give you kind of an overview of some of the main things that you need to know about what goes into a demand letter. A lot of this is the stuff I will say to my clients when we get on the phone. So let's look into that. Let's take a deep dive into that. What is a settlement demand letter? What is it for? So basically, a settlement demand is an opportunity for your attorney to write the insurance adjuster, or if there's a defense attorney, write the defense attorney, write that lawyer to make the case as to how much they should pay out in full and final settlement of your claim. Most of the time, we're talking about a full and final settlement, meaning they're going to pay out a lump sum of money, and that's going to settle the entire claim. You should know that really this is your only opportunity in a workers' compensation case to get a larger lump sum of money. Otherwise, especially if it's an accepted claim, as we've spoken about in some other videos, you're just going to be looking at getting that check once a week on an ongoing basis for up to potentially 500 weeks, all right? And get your medicals paid for. That's it. You're not going to get any large sum of money. This is your only opportunity to do that. Settlements are completely voluntary on the part of the insurance company, meaning that they don't have to settle. If they're paying you your benefits, and if they're paying you your medical benefits and your weekly check, then they're doing everything they're supposed to do, and they don't have to settle. But oftentimes we find that you'll reach a point in the case, especially if you've already gotten your functional capacity exam and gotten your permanent restrictions, reached maximum medical improvement, that they're going to approach your attorney and request a demand letter. There's three main portions of a settlement demand. The first is basically that your attorney is going to describe the relevant facts that have occurred up until now. What happened in the accident? What's the posture of the case? Where are we at? Have we done an award agreement? Have we done a stipulation order? Whatever. Where are we at with the case? What injuries are covered? What happened? And what is the basic course of your treatment? And where are we now? This letter has usually been prompted by the defense attorney or the adjuster's signal. That means that they've expressed interest in trying to put some authority on the claim. What does authority mean? That's a fancy word for saying money to try to settle the case. So then after that typically comes the second part, is a demand for what's called future indemnity, and if there's any past indemnity. What's indemnity mean? That's a fancy word of saying your weekly checks. So again, remember we said before that in most cases you're entitled, unless they can find you a job, the defense can find you a job, up to potentially 500 weeks of benefits from the date that they started paying you until 500 weeks. That's almost 10 years of benefits. It's a long time. So there's going to be a demand of some portion of those benefits, and also if they owe you anything in back benefits, there might be a discussion of that as well. Okay, so that's the second part. So we talked about the first part, which are the facts. Second part is indemnity. The third part is going to be the future medical payments, and if there are any past medical payments, anything unpaid so far, that'll be discussed. But future medical payments, and how do we do that? We basically looking at what your doctors say about the future, and we project that out for the remainder of your life expectancy. So those are the three main parts of your demand. Now let's go over each of these in a little more detail. So Again, the facts, if there's an awarded or accepted claim, your attorney may mention how you got hurt, how your injuries occurred. If there's already an award, they're not going to get into the facts too much. Why? Because it's not that important. You're already basically won your case if you're under an award or an accepted claim. Obviously, if your attorney is having to make a demand in a denied claim, okay, that's a different matter. He's going to spend a lot more time on the facts. After he does that, he talks about the facts of the accident if it's pertinent. He's going to get into the description of the injuries and treatment. Typically, when the demand goes out, as I've said before, you've reached maximum medical improvement and you've had some indication of what your permanent restrictions are, usually through a functional capacity exam. And I usually end the treatment with this discussion when I'm doing a demand with a detailed description as to what treatment you're going through now and you're continuing to undergo, including what medications, the precise dosages. I get into all that and what additional treatment has been contemplated by your authorized treating physician. Let's get into the first real element of demand, the indemnity. So how much, we're going to look at in indemnity? What are we looking at in terms of how many weeks we're going to claim, how much time into the future we're going to claim? And that depends on many factors. First and foremost, your restrictions. What are your restrictions per the functional capacity exam? If you can't go back to your job, the question then becomes, well, what are your transferable skills? How old are you? And what kind of money were you making? Let's take an example now. If you spent your entire work life in heavy manual labor, right? And let's say you worked your way up to $1,000 a week. And now because of your work injuries, your employer won't take you back. And you've restricted to basically desk work and you're age 59, meaning you're coming up on, you're heading toward retirement. What are the chances that you're going to be able to, be retrained for desk work at that age, maybe with a computer at a new employer? I'd say they're pretty slim, right? So on the other hand, if you're a fairly young person, you're in your 20s or your 30s, and you have a low wage rate, you have a lot of transferable office skills, let's say, it's going to be much easier to the other side to say, look, we're going to get this person into vocational rehabilitation, and we're going to be able to find them a job, and you don't get to project out much wages in the future, my friend, because we're going to find this young person with a lot of sedentary employment skills a job. In an awarded claim in Virginia, it's the defendant's burden, right, to prove that you can return to an occupation that within your physical restrictions. For a young person with a lot of transferable skills, much easier. For an older person, much harder. So we're going to be able to claim more money, more weeks for that person versus the young person with transferable skills. The person who's like lifetime heavy manual labor, $1,000 a week, they're entitled to 2/3 of their average weekly wage, right? $666.66 a week, right? That's 2/3 of $1,000 for up to 500 weeks. Now, let's say at the time of the demand, he or she had already been paid out about 60 weeks, okay? So it's been a little over a year since the accident. Now we're looking to settle. So that leaves 440 weeks left, and which comes out to about $293,000, okay, in potential future indemnity benefits. Even if they could find such person a job, we have to consider this too. What's the likelihood of them getting into a desk job paying $1,000 a week? Extremely low. So that might be a good place to start discussions on indemnity in a case like that. Let's say that this injured worker is not 59, as we discussed a moment ago, but 29. It's clearly not the same case. Definitely not. Why? Because that person doesn't have a lifetime of work behind them, where they've already had experience in one field, and furthermore, they're not nearing the age of retirement where, at the end of their work life is really just beginning. So what do we do there? Perhaps we figure out about how long it would take that person to become re-educated and retained to be able to engage in sedentary work, right? So maybe instead of 440 weeks, we are only taking maybe 2 years for retraining, which would be 104 weeks. That's another $69,000 or so, right? Big difference than, $293,000. You see how this kind of gets complicated depending on what age you are, what your experience is, etc. Let's take another example. Let's say we have an injured worker who's a young lady. She's only earning $500 a week, and she's doing desk work for many years. She's 40 years old, and she's restricted now to only sedentary desk work per her doctor, right? And on a permanent basis. There's a much greater chance that the vocational person, the vocational rehabilitation counselor, is going to find that person work, a job paying close to that amount because it's a lower amount. It's not, it's not $1,000, it's $500 a week. In that scenario, it wouldn't really make sense to project out the entire remainder of the 500 weeks, or even a big portion of it. right? Maybe we'd be looking at another year or so of saying she's going to be looking for a job for $500 a week in her skill set, in her sedentary skill set, which she has. So you see that there's a lot of different ways this could go depending on all these factors. Just for a moment, I just want to mention this subset of indemnity, which is what are called permanency ratings. And I encourage you to watch my video on permanency ratings, which, on our YouTube channel. I don't really want to go too far down that rabbit hole. I just want to mention it real quick. Let's say they do find this person the job, okay? Depending on what your injuries are, if you've injured a rateable body part, you may be entitled to some money for that. It's not usually a big payout. It's basically a permanency rating for a permanent injury to a specific body part. Usually it's a limb, a arm or leg or hand or foot, and you might be entitled to some money for that, but it never goes beyond 500 weeks. We typically find that unless we're talking about somebody who's going back to work, the ratings part of the claim is usually not very relevant. So we've talked about indemnity now. Let's go on to the next element, which are medicals. There are large amounts of medical bills that need to be dealt with, okay? And they have to be dealt with in the demand as well if there's outstanding medical bills that have been unpaid by workers' comp. On denied claims, this can get pretty significant. And we had a claim not that long ago of a gentleman who was staring down like over $1 million in unpaid medical bills going into mediation. Fortunately, the defense and wisely agreed to go ahead and pay all that as part of the settlement, in addition to other money that the person was paid in settlement of their claim. Particularly on an accepted claim, most of the time what we're doing, we're trying to project out in the future what the potential future medical payout is going to be for the rest of the injured worker's life. So obviously we kind of need to know how long you're going to live. Well, who knows that? Well, the good news is that there are laws that we're entitled to rely on that give the average life expectancy for people in your state. So in Virginia, we have a statute that gives an average life expectancy for males and females. North Carolina, there's a similar statute. So let's give a quick example. So let's say we have this, go back to this 59-year-old male who's a Virginia resident, okay? And at the time I'm making this video, according to the statute, we're entitled to assume, according to the law, that that person is going to live another 21.2 years. Now let's say our 59-year-old male injured worker has a couple of surgeries on his low back, okay, and he's restricted to sedentary duty, all right? Now, unfortunately, he's got lingering pain even after the surgery. Now the surgeon says that there's no further surgeries that are expected. However, he also says, why do we know he says this? Because we ask him in a letter where we ask him what his opinion is. He says that it is very likely that this gentleman is going to need pain management treatment for the remainder of his life for pain, although he probably will not need additional surgery. So now we look at the pain management. Let's say this person's had ongoing pain management treatment for a while, and we see that the pain management doctor has him on 3 pain medications for the last year or so that, based on our research, adds up to the cost. It's costing about $600 a month for that medication. Now you can project that out to a year. That's $7,200 a year. If you then multiply out the $7,200 a year times what we said before, was that his life expectancy, okay, of 21.2 years, you get a potential lifetime prescription cost of $152,640 for the remainder of the person's life. Now, is that it that we could project out? No, because we all know that these pain management doctors are not going to just write your prescriptions. They're going to require that you come in and see them at least 4 times a year. So if you look at an average cost of a couple $100 a visit, that's going to be $800 a year. Project that out times the number of, the 21.2 years, and you've got another $16,960. Add those 2 things together, the cost of the prescriptions and the future cost of the doctor and pain management doctor, and you've got $169,600. Let's go back on what we've done so far. We've talked about said we've got a first part of the demand which recites the general facts, second part which talks about the indemnity or the weekly checks, projects that out into the future depending on all these factors, okay? And then we got the third part of the demand which talks about the medicals, okay? And then what I typically do at the end, I will do what's called a recapitulation or recap, which I will then add up all those figures and then recommend a total amount for a full and final settlement based on all these factors and all those figures. What you should have learned by now, though, is that this is not something, particularly on a case where you've got a severe and permanent injury that you should try at home. Okay, you should not try this at home. And I've given very, very oversimplified versions of a possible demand, but there's so many factors that can affect what the actual demand will be. So before attempting to negotiate any case like this, I strongly urge you to contact a workers' compensation attorney who's very experienced in workers' compensation. If you've applied and been accepted for Social Security disability, which many folks do, you may need to participate and get what's called a Medicare set-aside, okay? And if you don't get a Medicare set-aside, you can really get messed up with Medicare. Every now and then we find that the workers' compensation insurance company will use this Medicare set-aside as a ploy to try to reduce the potential value or the apparent value of what your future medicals are. Besides all the other elements of the demand that can come in, namely the future temporary total disability, meaning your future checks and your future medicals, you may also have a right to claim an additional future cost for something that's called attendant care, okay? Now in North Carolina, this can even be claimed if your spouse is performing any of the duties that, let's say, if you didn't have a spouse, you'd have to hire somebody to do, okay? And you can get money to use as if you're paying your spouse for that, okay? And if you have Medicare, guess what? It's not included in the Medicare set-aside. And these figures, can add up very, very fast. I mean, if you're talking about $12 an hour or something like that and you're looking at 20, 30 hours a week over many years, you can be talking about a significant sum of money projected out into the future for attendant care. Overall, I hope this video has been helpful to you to give you some understanding as to what goes into a settlement demand when we attorneys send out one to the insurance company or to opposing counsel. This video is not designed to enable you to go out and on your own and do your own settlement demand, not by any margin. It's just meant as a general guide to give you or a loved one who suffered a work injury just some idea of what we're looking at, so that when you get to the point in the workers' compensation case where it's time to do the demand, it won't be such a mystery to you. Also hope you've learned that, particularly if you have a very severe injury, don't try it at home. Don't try to do it on your own. There are just too many factors that can go into a settlement demand that need to be considered. And really, you should be consulting a experienced workers' compensation attorney to evaluate your claim as precisely as possible to make sure nothing is missed. If you have any questions about workers' compensation settlements, settlement demands, or anything having to do with workers' compensation in Virginia or North Carolina, please do not hesitate to contact our office and our team here at Joe Miller Law. I'll be happy to answer your questions. In the meantime, God bless. Joe Miller out.